Hey, yo, folks, and welcome. Hold on. It's Tuesday. Is the last day or the deadline for defense motions regarding what happened at the ex parte meeting and moving and the rest of the trial, more or less, for the judge to consider. And out first is Mr. Weinstein, and he went for the throat. So read a few parts of it because I wanted a raw reaction with you guys, and he's not holding back, Mr. Weinstein. A motion for mistrial. Also, a renewed motion for bond for Mr. Diamante Kendrick. So I'm I'm going right into it. So if you aren't here, well, go back and watch if you started watching later. But welcome to the show, folks. Okay, let's start with the second renew motion for bond. Comes now, the defendant in above styled case, and move this honorable court to set a reasonable bond pending the disposition of this case, showing the court the following: that to present date, no bond has been issued for the above mentioned Kendrick. Kendrick is currently being held in Fulton County Jail for over 2 years, since May 9th, 2022, charged with the following 9 counts: 1, 2, and 57 to 63. 3. Kendricks was denied bond in 2022 and 2023 after the start argued that defendant and his co-defendant were a danger to his community. 4. Since the denial of bond in 2023, the state has presented its case in a plodding manner with no apparent concern that Kendrick and his co-defendants at trial are incarcerated, presenting witness lists that have at times topped 700 witnesses. To date, the state has presented almost 100 witnesses with no end in sight. While the state has argued that Kendrick is a threat to the community, None of the state's 100 witnesses has presented any testimony demonstrating that threat. The state has had 7 months to do so and has failed. 6. Since the denial of bond, the state has offered and entered into a plea agreement with at least defendants Murphy, Arnold, Stevens, Greer, Kitchens, Sledge, and Lee, permitting them to return to the community. This offer was despite having previously argued to this honorable court that those defendants posed a threat to the community. The court, having been convinced by the state's arguments before, should no longer provide the state with the benefit of the doubt. One must now question how much of a threat the state truly believes these defendants pose. That's a good argument. Therefore, any arguments made by the state in opposition to this motion ring hollow. 7. This court has granted bond to defendant Miles Farley following his severance from the present trial. 8. That Kendrick poses no significant risk of fleeing from the jurisdiction of this court or failing to appear in court when required, and is not an extraordinary bail risk. 9. That Kendrick poses no significant threat or danger to any person, to the community, or any property in the community, and will not jeopardize the safety of the community if admitted to bail in this case. 10. That Kendrick poses no significant risk of committing any crime pending trial. 11. That Kendrick poses no risk of intimidating witnesses or otherwise obstructing the administration of justice. 12. Kendrick assures this court that, if admitted to bail, he will neither flee nor go into hiding, but will respect to each and all orders of this court as directed. 13. Reasonable bond, by definition, is one which is adequate to assure that the principal accused will return to face the judgment of this court, but at the same time, one which is attainable by the client. In this case, the court's failure to set a reasonable bond for Kendrick has kept him incarcerated since the date of his arrest. 14. If Kendrick were to be granted a reasonable bond and through a surety authorized by the state of Georgia, he could return to his employment and aid counsel in preparing his defense to the charges in this case. 15. A rule nisi is attached here for the convenience of the court. Therefore, Kendrick prays that the court set a reasonable surety bond pending the disposition of this case. Respectfully submitted, Douglas Weinstein, ABT Law Firm, LLC, KDA Hingerty, the Hingerty Law Firm. Yeah, we don't need to read the rest of that. So, yeah, that was... So that was the bond motion. Let's see who we have here. Jar is here. Jar. No Binks. Hello, Snivels. And breaking it down with B. Jason, it's Bree. Kristen Vasquez, Mike Lee. Sir Frank Arthur, Christine. Louis Bagels. And Iron Rabbit. And a bunch of other people are already here. Hello and welcome. Yeah, I mean, all the defendants in these 6 defendants have been in jail since May of 2022. 2 years and 2 months, which is, in my opinion, within the range of any punishment for parts of this part of the charges. So now we are into the range where even if convicted on a few of the lesser points, they are facing time served. I wish that Mr. Weinstein had that point in, but this is a good one. This is a good start, isn't it? Amy CD, hello. But I assume we are all here for the good stuff. The good stuff is Attorney Weinstein, and you've seen him on my show on a few occasions. And I hope I will see him again on Friday on the panel show where we discuss and debate all this. Yeah, Friday, 6 p.m. panel show. And I wish us good morning. And Demisha Cash. I'm sorry if I am butchering your names. I am not American. Serious question, Nick. What happens to corrupt government employees in Sweden? Sweden is a social democratic bureaucracy. They rarely face consequences, and when they do, they are moved sideways, told to keep silent, wait for it to blow over, and then it's back to normal. Yeah, Sweden is not a corrupt country in that it had people handing over money and bars of gold, but instead Sweden is a country where government officials are treated to travels, and or not treated to travels, but for instance, this happened in my county not that long ago, and it was an uproar of suburban moms when they discovered, when building a certain something, the elected officials, went to a conference in Europe, an architect conference, all expenses paid, to watch and maybe decide what kind of building they wanted to build. Yeah, you don't need to go to fucking Italy for that one. Absolute asshole. Oh, okay. Yeah, I'm kind of furious about it because it's a hideous building. I might show you that on that's amazing building. I will show you that in a members only stream because that is that pissed me the right off. Yeah, Stern talking to with a high five like in the States. Yeah, maybe we're not that different. But let's go to the good stuff now. Hello, DK Cripple is here as well. Let's go to the good stuff. Let's see here. Can I make this a bit bigger? Yep. The stay in the Superior Court of Fulton County, State of Georgia, versus the Amonte Kendrick defendant, case number that one. The Amonte Kendrick's motion for mistrial comes now. The Amonte Kendrick petitioner, by and through his undersigned counsels, Doug Weinstein, and brings this motion for mistrial, showing as follows. Quote from Jones v. State, Georgia, Jones v. State, quoting United States v. Perez, 1824. Here we go. Well, thank you, Nana Misty. Thank you so much for $2 super chat. Good morning, Nick, Mods, and Viking folks. Yeah. Quote, we think that in all cases of this nature, the law has invested courts of justice with the authority to discharge a jury from giving any verdict whenever, in their opinion, taking all the circumstances into consideration, there is a manifest necessity for the act, or the ends of public justice would otherwise be defeated. They are to exercise a sound discretion on the subject, and it is impossible to define all the circumstances, which would render it proper to interfere. But, after all, they have the right to order the discharge, and the security which the public have for the faithful, sound and conscientious exercise of this discretion rests in this, as in other cases, upon the responsibility of the judges under their oaths of office. Continuing. The state has had witness after witness fail to provide the testimony that it would like the jury to hear. Rarely in the recent history of Fulton County Superior Court has one party had to impeach so many of their own witnesses. Yeah. Including at least the following key witness: Trontavious Stevens, Walter Murphy, Archelian Bennett, Eduardo Nava Flores, Adrian Bean, D'Angelo White, and critically, Kenneth Copeland. What is the state to do? Losing its case, apparently unconcerned about the need for public justice. Oh, Doug, you are not holding back here. The state clearly sought an opportunity to restart the trial by triggering an event in such egregious violation of the constitutional rights of Kendrick that he would have no choice but to request a mistrial. Now, goaded by the state and the actions of Chief Judge Glanville, Kendrick has no option but to move this court for a mistrial to respect the constitutional rights of Kendrick and not defeat the ends of public justice. While this trial has been riddled with the scores of errors, at least 3 demand an immediate mistrial. Hello, Diogo. Oh. First, placed by an impossible motion by the state, this court is faced with the task and requirement to reset this case to at least the point, the afternoon of June 12, 2024, when Kendrick moved Chief Judge Glanville to recuse himself, and he improperly failed to halt all proceedings pending determination of recusal. Since that date, the jury heard days of testimony from Mr. Kenneth Copeland, testimony that can't be unheard. Yeah, remember, even though, well, it's been 7 months, what does a few days matter? Folks, most murder trials takes less time to get to the jury than the few days of Mr. Copeland on the stand. Remember last week, the trial I was covering? Florida v. What's his face? No, Iowa versus Daisy. That was a 2-day trial. An hour, 2 hours of closing arguments. And then the jury was back after 1 hour and 40 minutes. So in 2.5 days, that murder trial started, all the evidence, closing, verdict in less than 3 days. That is what I want you guys to think about, and the Fulton County Court with Judge Whitaker. Most trials are done, and major trials are done within the time span that Mr. Kendrick continued testifying after the motion of recusal. And so this is a big deal, in my opinion, a very big deal. Second, Kendrick's constitutional rights were violated when neither he nor his attorneys were present at a critical stage of the proceedings, the secret ex parte meeting among the state, Chief Judge Glanville, Copeland, state investigators, court staff, and deputies. Third, Kendrick's due process rights were violated when Chief Judge Glanville wrongly coerced Copeland to testify. None of the above 3 reasons for mistrial would exist absent the state's intention to goad Kendrick into the unfortunate position of having to regretfully request a mistrial. Yeah. All of this, the Foster clock, we have seen the past month now. It's all on the state and Judge Glanville. All of it. None of it can be blamed on the defense. Not an inch, not a scintilla, nothing can be blamed on the defense. Background. Here we go. We get the background on everything here. In January of 2023, 2022, I think he means. No, 2023. Jesus Christ. January of 2023, nearly 18 months ago. Trial began in Fulton County Superior Court in State v. Diamante Kendrick et al. Jury selection took more than 10 months, with trial before the selected jury beginning November 2023. A secret ex parte meeting was held on June 10th, 2024. In attendance was Chief Judge Glanville, sworn witness Kenneth Copeland, prosecutors Love and Hilton, investigators from the Fulton County DA's office, court staff, and members of the Fulton County Sheriff's Office. A central figure, perhaps the central figure in the state's case against Kendrick and the other defendants is Mr. Kenneth Copeland. Sydney is here, a reformed convict. Hey, yo. On Friday, June 7th, 2024, Kendrick and the other Copeland was sworn in. After being given a grant of immunity and being warned by Chief Judge Glanville that incarceration may be the result of refusing to testify, Copeland continued to plead the fifth. Copeland was held in contempt and ordered incarcerated by Glanville on that date. Judge Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10th at 8:30 a.m., where Copeland would announce whether he was prepared to testify. Defense counsel were told to be present in court at that time and were in fact present. Unknown to any member of the defense counsel, an ex parte proceeding was held in Chief Judge Glanville's chambers on that date. Among the attendees were Chief Judge Glanville, ADA Love, ADA Hilton, investigators of the Fulton County District Attorney's Office, deputies, sworn witness Copeland, court staff, and Copeland's attorney, Miss Kayla Bumpus. No member of defense counsel were present at the ex parte proceeding, despite Copeland's invocation of his Fifth Amendment rights and the meeting being a critical phase of the trial. Neither Chief Judge Glanville, any member of court staff, nor the Fulton County DA's office made any members of the defense counsel aware of the ex parte proceeding either before, during, or after the proceeding. I tell everyone to call me D. Okay, I will try to remember that. D Cash. Or just D. It's Bree. And Sydney. Hello and Raynette. I just saw your name pop up here. Yay! Good. Several defense counsel were later made aware of the ex parte proceeding with sworn witness Copeland, though not from Glanville nor the DA's office. Critically, Brady material was disclosed in the ex parte proceeding and withheld from all defense counsel. Brady material. Well, this is US v. Brady, bunch of years ago, many years ago, when it was determined in the Supreme Court, United States Supreme Court, that if evidence is disclosed or discovered by the prosecutors and it's not handed over to the defense, that is a Brady violation, as was determined in the US v. Brady. The state have an obligation, a constitutional one, to hand over evidence to the defense. Now, there has been no question about that stuff for many, many years. Many, many, many years. A review of the recently released transcript of the ex parte proceeding reveals the occurrence of the following events. Copeland announced he would invoke his Fifth Amendment right and not testify. Copeland stated that he would rather sit in jail for 2 years than testify. Judge Glanville informed Copeland that Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. I believe this is one of the things that has the potential of being a statute, if needed. That you can't hold a witness for the state incarcerated. Now, incarcerated to the end of a trial. Yeah, we all understand that. When that rule was put in place, did they ever consider that Fannie Willis, I don't care how she pronounces her name anymore, because I don't have. I understand that. I've been told by Doug and others, it's very rude to not pronounce people's names. And if I've never met you before and you tell me this is how I pronounce my name, I will try to do that. Even if I think you are an ass, I will still try to pronounce your name right. Fannie Willis. It's not that I don't respect her. I believe she is a violation of the entirety of the court system by her corruption. I have absolute zero respect for her. So I don't care how I pronounce her name. If I make it correct one time, sure, good on her. If I don't care, because she's corrupt. Yeah. But this with threatening a witness with years in jail. Who knows when the last person is tried in this thing? 5 years? 10 years? Yeah, I think that should be a statute that no, you cannot do that. Next point. Copeland was informed that there were over a dozen defendants left to try. Following the above coercive actions by Judge Glanville, working in concert with the state, sworn witness Copeland stated that at the ex parte proceeding that he would testify. Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte proceeding. Copeland stated he would lie on the stand. Yeah. Exactly, Denise says. Brady was what ended the Alec Baldwin trial. And the evidence in that trial that already been presented and was about to be presented were good evidence. Really good. Not the fuster clock we see here in Fulton County with this RICO. I can say it out loud regarding the Alec Baldwin trial. The evidence was so good that had everything been heard, I don't think the defense could have done much about it. The state never gave Kendrick these critical Brady materials. These troubling facts not only implicate Judge Glanville in an impermissible effort to join forces with the state to coerce Copeland to testify, but also demonstrate an illicit effort to repress Brady material that should be provided to Kendrick. Following the secret ex parte proceeding, Petitioner filed and presented a motion to recuse an accompanying affidavit from Douglas Weinstein to Chief Judge Glanville on June 12, 2024. The motion to recuse was based on the impermissible secrecy of the ex parte proceeding and violations of the Judicial Code of Conduct that occurred during that secret proceeding. The motion was summarily denied instanter with a formal order issued on June 14, 2024. Yeah, here is one of the roadblocks any motion with the ex parte meeting has to face. And this is Judge Krause's absolute idiotic ruling that she did not see anything wrong with the conduct and what was said in the ex parte meeting. I mean, it's stupid. It is so. And she didn't reference any case law. She really didn't. The extensive motions filed by Weinstein and Steele, she didn't address anything. She just, yeah. And I think it was planned in that she couldn't avoid recusing Judge Glanville because it was so obvious against the rules. But in a misguided attempt to save the trial, she made a conclusion that she, in my opinion, had no legal basis to do. Let's continue. Despite meeting all requirements of Uniform Superior Court Rule 25, the motion for recusal was summarily denied without following the required procedure. A formal order denying the motion was entered on June 14th, 2 days after the motion for recusal was filed. On July 1st, Chief Judge Glanville reversed his order of June 14 and referred Kendricks' motion to recuse to another judge to determine the merits of Kendricks' recusal motion. On July 15, Judge Krause recused Judge Glanville. Headline here. Mistrial is required as all proceedings after June 12th are void. This honorable court is now faced with the inevitable and impossible task of rewinding the case to the afternoon of June 12th, 2024. From Probst v. Morgan, 2011. If a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and of no effect. Kendrick moved Judge Glanville to recuse during the afternoon of June 12th, and he denied that motion. Glanville failed to follow 25.3 by not halting proceedings and sending the recusal motion to another judge to rule on the recusal. Subsequently, Judge Krause on July 15 found that Judge Glanville should have been disqualified. Therefore, under Probst, all proceedings since the afternoon of June 12th are invalid and have no effect. D asks, what happens if other inmates come forward accusing ex parte meeting occurred while being prosecuted by ADA, Love, and Hilton? They need to have a lawyer to find transcript of ex parte meetings that wasn't discovered during trial. They need to find it and they need to put it in an appeal or in a it will be really, really hard. It will be really, really hard if the people are already convicted to have it reversed by this alone. And if you mean if people took plea deals, I don't think that has any bearing. But if they are convicted people in Fulton County, they need to find themselves a lawyer that can find it. And if it exists, yeah, it's for the appellate courts. And for the people who took plea deals, I don't think it is, because that is outside of trial, so to speak. But yeah, as always, find a good lawyer. Find a good lawyer. This honorable court is now saddled with the repercussions of Judge Glanville's failure to follow Rule 25. He should have halted all proceedings as required and referred Kendricks' motion to recuse for assignment to another judge. Yeah, he should. He didn't. Nevertheless, he persisted. Under repeated objections from Kendrick and other counsel, the tainted testimony of Copeland was presented to the jury over the course of 4 days. The remainder of the day on June 12th and on June 13th, June 14th and June 17th. Yeah, so the jury heard testimony on a time span a day longer than the entirety of the trial against Tyler Daisy, which was a murder trial, which was started, ran, ended, verdict, all within 3 days. That is how much time this jury was subjected to this misconduct. Now this court is tasked with unringing the bell. How is this court to accomplish this impossible task? How does this court take the jurors' notes from these days from the jurors? How can the jury unhear days and days of testimony? This is not a matter of a witness uttering a single statement that a court instructs the jury to disregard. It is neither feasible nor plausible that an instruction to disregard days of testimony can be followed. Instructing someone to not picture flying elephants only result in the listener conjuring images of Dumbo. Doug, you beast. Yeah, folks, let's try this. Hold on. Do not think of apple pie now. How many of you got the cravings for apple pie? And my apologies if you're on a diet and is now thinking about apple pie. Now I'm thinking of apple pie. And I don't have apple pie at home. Do I have apples? Yeah, I have apples. I have flour, I have butter. After this stream, I'm going to make myself some apple pie. Nom 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 nom. But back to this. Given the impossibility of erasing the proceedings since June 12th, proceedings that are void due to the state knowingly, improperly requesting Judge Glanville to hold an improper ex parte meeting with a sworn witness, and Glanville subsequently failing to hold proceedings as required, this honorable court has no alternative but to declare a mistrial. Oh, hello, MG Law. If you have time, I'm going to send MG an invite. MG. Dun, dun, dun. There. Sent you a link. I don't know if you can or not can. Okay, and Giraud is at the office, so maybe you can't. Maybe you can't. Okay, let's continue. This motion for mistrial would not exist absent the state requesting the improper ex parte meeting. Simply put, Kendrick was goaded into requesting this mistrial through the state's intentional effort to put Kendrick into this position. Now, the logic here is that the state, and this is both the prosecutor and Judge Glanville, since they chose to not follow the rules, it was their choice to not follow the rules. They should have reasonably known that the effect would be a motion to mistrial. A motion for mistrial. It would be reasonable because the conduct in that ex parte meeting and how Judge Glanville acted after the motions for his recusal should have reasonably told the prosecutor and the prosecutors to tell the judge, you must halt those proceedings. But since they are in cohort and in circus, they forced the hand of the defendants. Mistrial is required as the June 12th, 2024 secret ex parte meeting was at a critical state and violated Kendrick's rights. Kendrick's constitutional rights were violated when neither he nor his attorneys were present at a critical stage of the proceedings. The secret ex parte meeting among the state, Glanville, Copeland, investigators, court staff, and deputies. Defendants were not provided notice of the hearing. And Allen v. State from 2020, quote, under both the federal and state constitution, a criminal defendant has a right to be present during critical stages of his trial. Yeah. You would assume that Mr. Copeland uttering the words, I did these crimes, quote unquote. That is Brady material, because that statement alone should have been handed over to the defense so they on cross-examination could ask, what crimes? And the state and Glanville actively hid this from the defense in order to undermine their ability to question Copeland on cross-examination. And many others. They will probably get to a few of the. They already said a few of the examples. Defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of their trial is being coerced to testify. A critical stage is one which a defendant's rights may be lost, defenses waived, privilege claimed or waived, or in one which the outcome of the case is substantially affected in some other way. Brennan v. State, Georgia, 2022. Here, the outcome of this case is substantially affected by the bullying of Copeland into changing his mind regarding testifying. Copeland is the key witness to the state's allegation that Kendrick was involved in the murder of Donovan Thomas. While the case against Kendrick is weak at best, even with the testimony of Copeland. Without Copeland, the state has virtually nothing attaching Kendrick to the murder of Thomas. The ex parte meeting with Copeland was thus a critical stage of the trial in which Kendrick had a right to participate. A mistrial should be ordered by this court given that Chief Judge Glanville denied Kendrick's constitutional rights to be present at a critical stage of the trial. The ex parte meeting with Copeland Furthermore, this mistrial is a direct result of the state putting into motion the ex parte meeting, knowing that such a meeting would goad Kendrick into moving for a mistrial. This is the part when Mr. Weinstein, he has argued mistrial. Now we are getting into the territory of mistrial with prejudice. Now, this is a much higher standard, much harder to achieve. Do I believe it should be granted? Yes, but you know me by now. Yeah, but even if I would take a helicopter position and detach everything, every prior bias I had about this, I would say still that they probably should. They probably should grant this mistrial with prejudice. Do I believe it will happen? Sadly, no. The Fulton County has invested somewhere in the region of, at least more than $5 million of money that phony Willis should have used for getting the court docket cleared, getting up to speed. Instead, they are having thousands of people being denied their day in court. Thousands for this trial, this pile of manure they call a RICO trial. Are you debating what topping to have on apple pie? Ice cream is a very good option. I actually prefer vanilla custard. Do you know why you have apple pie in a bowl? Or why you always should have apple pie in a bowl? Because then you can pour custard over until you can't see the apple pie. I wonder why I'm closing in on 300 pounds. Never mind. Let's continue. Mistrial is required as Judge Glanville tainted the proceedings by improperly coercing Copeland to testify. Copeland's testimony is tainted by the improper meeting prompted by the state, where Judge Glanville wrongly coerced Copeland to testify. Judge Glanville's coercion of testimony by sworn witness Copeland in the face of Copeland's repeated refusal to testify and Copeland's statements that he would lie on the stand was an act of impermissible intimidation and a violation of the Judicial Code of Conduct. Kendricks' constitutional rights to due process and a fair trial have been violated by the above actions, and the state's actions in working with Judge Glanville on the coercion has intentionally goaded Kendrick into the only possible outcome, this motion for mistrial that should be granted by this court. As a natural result of the state's actions, Judge Glanville has violated multiple rules of the Judicial Code of Conduct, the violation of which denied Kendrick's constitutional rights to due process and a fair trial. As requested by the state, Glanville had an improper ex parte proceeding, footnote 1, conducted with sworn witness Copeland. Let's see here. Here is footnote 1. Uniform Superior Court Rule 4.1 generally prohibits ex parte communications, quote, except as authorized by law or by rule. Judges shall neither initiate nor consider ex parte communication by interested parties or their attorneys concerning a pending or impending proceeding. Ex parte hearings are only authorized in the case of extraordinary matters such as temporary restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing with an opportunity to attending and voicing any objection that may be properly registered. Pendergrass v. Skelton, Georgia Appeals, 2006. Let's see. Nathan Wade was on Comedy Central with Marlon Wayans. Oh, I need to see. I missed that one. Well, We have some time before the end of the week to search for other things, for me to present other things for you. Now, can I even show Comedy Central without being? We'll see what I can find. Jason prefers pumpkin pie. That's a choice. The secret ex parte proceeding with sworn witness Copeland was also a violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which assures every person a fair hearing. Ex parte communications are presumed to have been in error. City of Pendergrass v. Skelton. Yeah, presumed to be in error. Did I miss one? Oh, footnote 2. Here is footnote 2. Georgia Code of Judicial Conduct 2.9. Assuring fair hearings and averting ex parte communication provides A. Judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. 1. Where circumstances require, ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that A. The judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communications. And here I can argue to kingdom come that the coercion in that ex parte meeting gave the state a tactical advantage, procedural, substantive, and or tactical advantage against the defense. Sweet potato pie. Oh, that's a good one. Yeah, I will probably get a strike if I show Comedy Central. Yeah. Okay, both Good Logic and Robert G got a strike showing it. Okay. That's a good heads up. Thank you. B. The judges makes provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. Yeah, clearly Glanville is in violation of 1B. 2. Judges may obtain the advice of a disinterested expert on the law applicable on a proceeding before the court if they give notice to the parties of the person consulted and the substance of the advice and afford the parties reasonable opportunity to respond. Well, Glanville did not oblige to this part at all. We say that. Likely prompted by the state, not only did Chief Judge Glanville fail to notify defense counsel about the ex parte proceedings as required by Rule 2.9, but Chief Judge Glanville made every effort to conceal the proceeding. Glanville should not have coerced sworn witness Copeland to testify. Quote, a trial judge should not attempt to intimidate a witness to testify in behalf of the state, either in or out of the presence of the jury. Win v. State. Georgia Appeals 1976. See also Benton v. State, Georgia Appeals 1938. This is old case law. The situation of the present case is analogous to the situation in Webb v. Texas. While in Webb, a trial judge intimidated a defense witness into not testifying, the corollary is present here when a trial judge, Judge Glanville, initiated a state witness into testifying. The Supreme Court's language in Webb is instructive. We had a lot of footnotes here. Footnote 3. Judges may consult with court staff and court officials whose function are to aid in carrying out adjudicative responsibilities or with other judges, provided that the judge makes reasonable efforts to avoid receiving factual information that is not part of the record and does not abrogate the responsibility personally to decide the matter. The judge didn't do that. Judges may, with the consent of the parties, confer separately with the parties or the lawyers in an effort to mediate or settle pending proceedings. He did not do that. Judges may initiate, permit, or consider ex parte communications when authorized by law to do so, such as when issuing temporary protective orders, arrest warrants, or search warrants, or when serving on the therapeutic, problem-solving, or accountability courts, including drug courts, mental health courts, and veterans courts. Not applicable here. In reversing a conviction, the Supreme Court said that, in light of the great disparity between the posture of the presiding judge and that of a witness in these circumstances, the unnecessarily strong terms used by the judge could well have exerted such duress on the witness mind as to preclude him from making a free and voluntary choice whether or not to testify. That same disparity occurred with Copeland. A trial judge in his chambers, in cooperation with prosecutors, surrounded by investigators and law enforcement, coerced Copeland with the threat of years of jailing. The state and the judge exerted such duress to preclude Copeland from making a free and voluntary choice whether to testify. Thus, Kendricks, who was neither present nor represented in the ex parte meeting, was deprived of his 14th Amendment due process rights. As in Webb, this court can't, quote, repair the infringement of the defendant's due process rights under the 14th Amendment, end quote. Regardless of whether the violation was under Webb or Wynne, Kendricks' rights were violated by the judge's intimidation and coercion of Copeland. As the state likely expected, Kendricks has now been goaded into seeking a mistrial because of this due process violation and respectfully, regretfully, requests a mistrial. Wherefore, Kendricks respectfully and regretfully requests this honorable court to declare a mistrial based on the practical impossibility of voiding the case after June 12th, the violation of Kendricks' rights by his being absent at the critical state of the proceeding, and or the tainting of the testimony of Copeland by the improper coercion of his testimony by Chief Judge Glanville. Furthermore, Kendricks respectfully requests his honorable court find that this request for mistrial was goaded by the state when it requested that Judge Glanville hold the ex parte meeting, absented Kendricks from the meeting, and joined with Chief Judge Glanville in coercion of Copeland. 23rd of July, 2024. Douglas Weinstein, J. Abt, Hingerty. Yeah, here is the rule Nisi. We will get into that in a bit. Yeah, this is a good motion that should be granted. Should be. Now, we still need to... Now the prosecution has until Friday to respond to this. I have no illusions that they will file some absolute horseshit garbage, misstating case law, because that is what they have done before. The difference now, they don't have Judge Glanville. They do not have Judge Glanville to do the dirty work. Culparistic. The judge who recused Glanville said the meeting was proper. I don't know how this isn't a non-starter. This is a different judge. Even if that judge, and that might be because Mr. Weinstein does not address this in this motion. Will that force Judge Whitaker to make a ruling? Either if she rules against that judge, or she doesn't, or maybe she just concludes that, well, Judge Krause says it wasn't. That in itself is an what I would call an unforced error. This is an appellate issue. The difference now is Judge Glanville would never give out the certificate in order for this to have immediate appeal. Because if she finds that Judge Krause's decision to ex parte meeting, blah, 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 never mind, then that is a big appellate issue. Big appellate issue. But yes, that is the big hurdle against, at least regarding the ex parte meeting. Now, the big part here is still, how do you unhear? How do you unring the bell? How do you unfuck a clusterfuck? How? You can't. It's impossible. There's no jury instruction in the world that can make the jury disregard 3.5 days of testimony. So it's in two parts. So mistrial without prejudice, that is the Judge Glanville's conduct. Mistrial with prejudice is the ex parte meeting. But we don't know how the judge will rule, because today is the last day of the defense motions. The state, the prosecutors has until Friday to file replies. And then next Tuesday, then the hearing starts about these motions. That will be really, really interesting. Really, really interesting. If this goes to hearing, I hope that they can find an expert in this area, a well-respected expert, maybe a retired judge or something, maybe a retired Supreme Court judge or appellate judge or something of the sort that can testify to the absolute horse shit that was the ex parte meeting. Something of the sort. If that is the kind of hearing that the defense can do this with. I don't know. I'm just checking here. Let's see if... So far, it seems like only Mr. Weinstein has filed his motion so far. We still have until the end of the day to for the rest of the parties to file their motions. Yeah, reformed convict says, it enrages me at the lack of care for those whose lives are stuck waiting for this trial without bond, and how they can seem so unconcerned that the defendants can spend their lives locked up. Yeah, I agree. Raynette, if Woody is a liar, why do you believe him? Because he said, I did these crimes. You pick and choose what lies you want to believe. No, I don't care. The thing is not what he said. The thing is that what he said was the information is denied the defense so they can cross-examine on it. What crimes is Woody talking about? Because a part of the trial is when you have a witness that is this crucial, is for the defense attorneys to utterly destroy his destroy him, so to speak, on the stand, so that the jury cannot take him seriously. Oh, not me, the person in chat. Okay. Thank you for clarifying it. Thank you. So it doesn't really matter what Woody said in there. Is that what he said was denied? That information was denied the defense. And that not only I did these crimes, or I did whatever the quote is, but also he would lie on the stand. He was more or less granted immunity for lying on the stand from the prosecution. There's a lot of crap going on. A lot of crap. Let's see here. Rule Nisi. I'm not sure what that is. In the Superior Court of Fulton County, State of Georgia. Georgia v. Kendricks. Rule Nisi. Oh. Okay, Rule Nisi. This is the suggestion from the defense how Judge Whitaker should rule. This is their suggestion of the form to use for the judge. It's a nudge. Just fill it in, Judge Whitaker. Now, wherefore the defendants have filed a motion to mistrial in the above captioned matter. It is hereby ordered that the defendants of a motion shall be set down for hearing on a certain date to wit. And okay, so not exactly, here's how you should rule, just set the hearing date for this. Now they already set the hearing date for the hearings, for the motions, which is Tuesday. So not a lot of time for the prosecution to make up garbage. Do you remember the last time? They asked for a 48-hour extended time for a reply for the recusal, and oh my God, it was hot garbage. I mean, if one of my trainees tried to write one of that, I would question that trainee's ability to practice law. Certificate of service. Yeah. Oi. See here. Do we have anything else at the moment? Oh yeah, I need to find that again. This amazing line from, where did it go? Instructing someone to not picture flying elephants would only result in the listener conjuring images of Dumbo. I would be amazed if the elephants in this example wasn't a donkey in an earlier draft. I would be amazed. That would be hilarious if this example, instead of being elephant, was a donkey. Because Doug Weinstein famously said, Prosecutor Love can talk the ears of a donkey, and then use a donkey in this. Donkey! Motion Mania! Yeah, now it starts. This Tuesday will be really, really interesting. Are you already done? Chat? No. Oh, you're already done. Yeah. Okay. Now we just have to wait for the next one. Now it is almost 8:30 p.m. here where I am. I assume Cap Not Williams will be I know she streamed this one as well. We both started streaming roughly at the same time, but stuff happens because we are all interested in getting this news out to as many people as possible. So if the next motion isn't in until the end of the court end of office hours, that is 5 p.m. Eastern, which is 11 p.m. my time. I have an early start. If I don't see new motion before 10 p.m., I need to go to bed. But you always have Cat, not Williams. You always have her to rely on getting you more news about these motions filed by the defendants. I will do a recap. No, I will do a stream tomorrow morning about that. About all the other motions that will show up before the end of today. Oh, but those are the motions. Those are the motions that this is the motion from there. This is the motion from Doug Weinstein in behalf of the Monte Kendrick. It's a good one. Now we have to wait and see. I assume Mr. Steele will file a motion. I assume there will be motions from all of them. I assume that Mr. Attorney Harvey will again file a motion of sever, which I also will cover. I mean, I will cover all the motions. And then on Friday, this will be interesting. Friday, 6 p.m., folks. It is Friday panel show with guests. I hope Kat can show up. I hope that the usual suspect. I hope the rest of them, that Mr. Weinstein can come on. I hope that infamous Sylvia can come on. I hope that Kayla Bumpus can come on. And other people to discuss what's been going on this week. And yeah, we will see who will show up. But 6 p.m. Friday. But I will return to you tomorrow morning at 8:45, 9 a.m., something like that, with the rest of the motions, unless the other motions are on their way in. If they are, I will, if they show up within an hour and a half, I will produce you another stream. But if they don't show up, I will stream them to you tomorrow. Okay. That is all I had for you, folks. That's all, folks. But yeah, we are living in interesting times. I'm still saddened that this is that the defendants are exposed to this absolute fustercluck that is the Fannie Willis political aspirations to become the next Attorney General. Now that hopefully is gone now. Even she might get elected in Fulton County, but I highly doubt she will be elected in the entire state of Georgia. Another thing coming is now that when you have a presidential election coming up, and that has also been interesting. Now, I'm not a political channel, but I do want to address in a coming stream what will the result of the election have on Fulton County. Because let's just say, if former President Trump is elected, I would assume that whatever contact Fani Willis had with the president leading up to this trial will be revealed. And that would be interesting. But again, that's for a later stream. Thank you, everybody, for showing up. Thank you for allowing me to do this. And hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Let's go out with Yeet the Judge. See you tomorrow. Bye-bye.
Gavel cracks, breaking backs, twist the facts, yeah. Rotten core, buried deep, justice cheap, hell. Crooked smile, snake and trial.